Hello, good evening. This is B.A. Nagesh, a retired civil servant. I am into mentoring students for the civil services and I've had excellent results from 2011. Most of my students are there in the All India services apart from the Group A. So today we'll be having a discussion on GS3 environment. Like I told you, the breakup of Gen Studies 3, economy, agriculture, science, technology, environment, internal security, disaster management. When I see the previous papers, the standard breakup of marks for the unit on environment is around 50 to 60 marks. And in environment, it is not the traditional things which are being asked. In the environment, I told you, the questions asked are all of the dynamic portion. Why the dynamic portion? It is because the upcoming civil servant, the future civil servant, should have a clear understanding of the issues which the country is facing, and what, as an administrator, what possible solutions, suggestions he can give. So, as I told you, whether this is an environment or in any other general studies paper, don't be critical of the government. You cannot, in your answer, you don't point out that the government has not done this, government has not done that. It is not your business at all. See, as a civil servant, you, future civil servant, you can give suggestions. These suggestions will be very much appreciated by the examiner. Okay. With this background, I will go to the question on GS3 environment. So this is a question relating to the National Green Tribunal. Instead of giving financial and administrative support to the National Green Tribunal, efforts are being directed towards diluting its powers, defeating the very purpose of its creation. So here what is happening is what the examiner wants is, what are the issues affecting the functioning of the National Green Tribunal? Then how can we strengthen this National Green Tribunal? So the National Green Tribunal is a quasi-judicial authority. As I told you in General Studies 2, we have a topic on constitutional bodies, statutory bodies, quasi-judicial bodies. So quasi-judicial bodies function more or less like a court, and they have power to impose costs, penalties, etc. First, with a brief introduction, how did the National Green Tribunal come into existence? Article 21, relating to life and liberty, the Supreme Court, in its liberal interpretation of Article 21, clearly stated that the right to life and liberty means the right to clean environment. So right to clean environment is a part of Article 21, and every citizen has the right for a clean environment. Keeping the judgment of the Supreme Court in the background, see, there were a lot of increase in the environmental cases. So environmental cases, these were clogging the regular judiciary, and the regular judiciary, with its burden of the routine cases, could not find time to hear the environmental cases. And again, there was a question of how the victims of pollution and environmental damage, how they have to be protected, what compensation has to be given to them. So keeping this in background, the National Green Tribunal came into existence. Now you see the question again. Instead of giving financial and administrative support to the National Green Tribunal, efforts are directed towards diluting its powers, defeating the purpose of its creation. So in this particular question, the examiner is not interested in knowing about the various judgments of the NGT. No, it is not a part of the answer. You go straight away with an introduction, you go to the what are the issues affecting the functioning of the National Green Tribunal. See, the National Green Tribunal is to compose of 10 judicial and 10 executive members. At any given time, these 10 judicial and 10 executive members are not filled. So there's always a vacancy in the composition of the National Green Tribunal. So when there is a vacancy in the composition of the members, the tribunal cannot work to its full capacity. Then you take the regional benches of the NGT. Now the regional benches which are there in different parts of the country are not functioning properly due to absence of members and due to, like, what shall I say, video conferencing. Now when video conferencing of the proceedings are taken up, many of the public will not know, frequent postponement, so it is not functioning in a proper manner. Now the NGT has 10 judicial, 10 executive members, all fine. Now you require experts to tackle certain areas, like say nuclear waste, biomedical waste, hazardous waste. We require experts who have knowledge of this. Only when such experts are taken can they contribute to the judgments of the National Green Tribunal. Then you see the definition of expert member. The NGT is supposed to consist of 10 judicial and 10 executive members. Now, in the category of expert member, what the government is doing, they are filling up the post of executive, the expert member from the IAS and IPS. See, with due respect to the IAS and IPS members who have retired and going as members of the NGT, how far would they be able to contribute to the functioning of the NGT? Obviously, their appointments are political in nature, and with what generalist experience can they function in this specialized body? Then you take the quantum of compensation to be paid by the polluter. See, this quantum of compensation is fixed without any scientific basis. It is an ad hoc, what shall I say, ad hoc method of calculating the compensation to be paid. So what is going to happen is the whole method of fixing compensation to be paid to the victims is done in a very arbitrary manner. Now, there are serious challenges in implementing the orders of the National Green Tribunal. What happens? The NGT says you deposit so much amount in the environmental relief fund within 30 days. What if you don't deposit within 30 days? What if the polluter does not pay? Then, challenging the NGT orders in the Supreme Court where heavy penalty is imposed. Once the NGT finds, like we discussed on about the LG Polymers case in Visakhapatnam, the Supreme Court said so much crores have to be, the NGT said so much crores have to be remitted to the relief fund, environmental relief fund within 30 days. What happened? Nothing happened. The LG Polymers went to the Supreme Court and got it stayed. So challenging the NGT orders in the Supreme Court where heavy penalty is imposed. Then, see, there is no institutional mechanism to ensure that the orders of the tribunal are complied with. See, the NGT gives an order. Now, which agency is there to see that it is complied with? See, the offending party will take the easy way out. The polluter also takes the easy way out. Now, the NGT does not have a mechanism to ensure that its orders are complied with. You take the Ganga water pollution, you take the illegal mining, you take issues related to solid waste management. We have umpteen orders of the NGT on these issues, and these are yet to be implemented. So I spoke about what efforts have to be taken to get rid of these challenging issues. I labeled it as issues of concern. Because unless these things are attended to, unless these things are rectified, the whole purpose of creating an environmental court, environmental ombudsman like the NGT will be defeated. So how do you wrap up your discussion on this? See, New Zealand and Australia have environmental courts which can impose costs. So what is happening is in New Zealand and Australia, whatever costs are imposed, that takes care of the administrative infrastructure, then it can take care of other issues. In the sense, what I'm trying to emphasize is the environmental courts in New Zealand and Australia are not dependent on the government. They can impose costs. So what is happening? Because they're empowered to impose costs, it increases efficiency, and it contributes to the overall functioning, better functioning. So this is something which is lacking in the National Green Tribunal. So summing up a discussion on the question, as I told you, the examiner is not interested in knowing about the various judgments of the NGT. The question is very specific. Instead of giving financial and administrative support to the NGT, efforts are directed towards diluting the powers. So in this, your main stress of the answer would be highlighting the issues of concern or highlighting the various issues which are preventing the NGT from working towards its objective. What are the objectives of the NGT? Polluter pays principle, checking the environment, awarding costs in case of environmental damage, then helping the victims of pollution through compensation. So these objectives can be fulfilled provided the issues raised are rectified. So you conclude your answer by giving the example of New Zealand and Australia, which have environmental courts, which can impose costs to increase efficiency and improve overall performance. So unless radical changes are made in the functioning of the NGT and structural reforms are taken, the NGT may not be able to deliver, or it may not be able to justify its existence. See, the main reason why the NGT came about is the liberal interpretation of Supreme Court of Article 21, right to clean environment. So if the individual has to have a right to clean environment, and if we have to punish the polluters, we should have an institutional mechanism to see that the orders of the NGT are being implemented, besides suggesting the structural reforms which is most necessary in promoting or making the NGT live up to its objective of cleaning, protecting the environment, and standing up to the expectations of the citizens. Thank you.